question says, I booked accommodation on Airbnb or through Airbnb. I was contacted a day before my check-in date to inform me of a mix-up with the booking. Someone else had booked as well. They are now stating, the owner of the property is stating, that they can't perform in terms of my booking. What are my rights? But the question goes further, and it also speaks about long-term rentals and says, likewise, how would this apply to a long-term rental where two lease agreements are signed for the same property? Cilna?
Well, the first part of the question, I almost want to say, it's Airbnb. I mean, the app is designed in a way, and even if you book through the website or whatever, it's designed in a way where it's really impossible to double book the same accommodation if everybody is in fact using the Airbnb app. However, it does often happen that Airbnb owners use Airbnb on the one side, but then they also do their own little different sort of arrangements, and they confuse their booking books. And the truth of the matter is, now my answer becomes exactly the same as it would be in the second part of the question. So the first part of the question, if the owner is working exclusively through Airbnb, these mix-up can't happen. And for the viewer's benefit, practically, if it did happen, it means now this owner didn't exclusively list through Airbnb. My advice would be go through Airbnb to their customer service complaint lines, those kind of things, send along, heavily worded email, I am such a sad panda, this happened, and Airbnb will sort that out. That is why we book through well-known apps like Airbnb or Uber or whatever your type of service is. Checkers 60 is my new favorite thing in the world. I'm saving so much money not walking through Woolies aisles. So just use the right apps. But to the second part of the question, and which would be my answer as well, if this Airbnb host listed on Airbnb, but then did a private rental on the side. We have a very simple rule in law called it's called prior est tempore, prior est jure. It's Latin for first in time, first in right. So the first agreement that was concluded would be the agreement that stands. So it's quite simple. If two lease agreements were signed, you would look at which one was concluded first. If there were specific terms delaying conclusion, that has to be taken into consideration. But the agreement that was concluded first will be the agreement that stands, and it's based on a very, very old principle in law. And I must say, I think it feels like a very simple answer. Bruno, what am I missing?
No, nothing at all. It is that. So I suppose, look, I suppose that's the thing. If we try to draw the analogy between short-term and long-term leases, you can always then start arguing things like damages and the like, because if a person tries to enter into a contract that they're not actually entitled to enter into, because I mean, they've already entered into a contract, that contract governs rights, and now they're trying to enter into a second one. Obviously, that's not enforceable. And if you were to have suffered damages, sure, you might actually be able to claim on those damages. Risk in situations like this is the quantum of the damages. So Airbnb, yes, there's an inconvenience component to it. Maybe you found the property very, very cheap, and the next property is going to cost you 200, 300 Rand more. Are you going to try and claim that? You probably have a better chance complaining at Airbnb, mentioning this, and you'd probably land up with a 300 Rand voucher, or this owner actually apologizing and saying, you know what, next time you're around, come stay. That's probably your best bet. So legally speaking, the answer is yes, you've got a right to claim damages. Practically speaking, no one would ever follow that path. Long-term rentals, Similar, because at the end of the day, now one has to look on a month-to-month basis. I can imagine, for example, if it was a commercial lease with a business, it would be a completely different story, because there you're looking at very, very large square meters. And since you're paying per square meter, if you find something and somehow this prejudices you and you're now not able to find something else and you go a month without trading and yeah, different story. And like if it just happens the night before and you're about to move into your place and you've like canceled your previous lease, sure, you could probably land up claiming like a month, a couple of days at a hotel or something along those lines, because now you've had to go find something else. But yeah, so what Cilna says is 100%. So this just kind of adds on to the potential that there are damages, and depending on what these damages are, would justify whether you'd actually try and claim them or not.
And I'm also assuming that, and around what both of you are saying, is that the Consumer Protection Act come into effect with double booking, for instance, on the Airbnb example. Am I correct? And your damages then would potentially relate to, or could it? I'm asking the question to Bruno Cilna, where if that owner is unable to provide me with the accommodation, I go and book elsewhere, that they should then cover the difference in the amount. Is that how it works, or in terms of the double booking rule?
Chris, honestly, the application of the CPA on lease agreements, it doesn't find application easily, except obviously for Section 14, which specifically says it deals with fixed term lease agreements. A lease agreement, in terms of the definitions of the Consumer Protection Act, does fall within the definition of a consumer agreement. But in terms of the definitions of suppliers, services, those things, leases, rentals are specifically excluded. So I don't want to confuse our viewers now by giving a very technical legal answer. Section 14 of the Consumer Protection Act will find application in by far the majority of residential lease agreements, and I would put it on more than 80%, where you do need to give the tenant 20 business days to remedy his breach before you can cancel, or where the tenant can give 20 business days notice of cancellation. The rest of the CPA, for instance, Section 16, the cooling off period, or for instance, this double booking situation, those type of services are specifically excluded from the ambit of the Act. And I'm answering this very carefully, because if I hear ever after this that somebody says, Cilna, Steyn said the CPA does not apply to leases, I am running away so far, because that's not what I said. But remember, the CPA, an act is not a singular thing, and especially the CPA is multifaceted. Section 14 definitely most of the time will apply to residential leases, but definitely not in a case like this. It's most likely specifically excluded from the ambit of that particular sections relating to non-performance in terms of a purchase. Did you see how careful I answered that one?
Very carefully, but thank you for that.
It's a pleasure.